Okay. So first of all, I would like to ask if you uh, are able to hear me properly and the PPT is available. I have already projected the slide.
Yes, sir, you are audible.
Okay. So I'll just so the slide that you can see over here, uh, right. So this is, the Insolvency and Bankruptcy Code was drafted in 2016 and mostly came into force since November. Through these last 7 years or so, we've had several examples of the corporate insolvency resolution applications being filed. And recently, the IBBI has come up with this data. So, this chart is in the recent IBBI newsletter, which is of the April to June 2023. So, if you look at these details, so till April, June 2023, all of these many applications were admitted. So if we look at the total, around 6,800 applications are admitted, and appeal review settled 1,005. Then closure by withdrawal under 2012A was 897, approval of resolution plan 720, commencement of liquidation 2120, and the CIRP pending is 2073. The pie chart shows that 55% of cases have been resolved through appeal, review, settlement, or withdrawal, and 45% have gone to liquidation. There is another chart which provides these bars into the respective numbers of the insolvency applications admitted, how many are closed, and how many are ongoing. So this data, if you are able to look, is basically shows that the uh, percentage of the insolvency applications which are resolved or are withdrawn or settled are more at 55%, and all those who have gone for liquidation are 45%. So it basically shows that there are more number of insolvency which are resolved. Now in this IBC case laws session, I am going to present and discuss few recent cases related to insolvency. The first case that I would like to discuss is the case of Go Airlines, and it's a contemporary case. It is still going on, and I will discuss till the extent that it has been the proceedings are ongoing. So the insolvency application was admitted at the NCLT. This was a special bench, and the insolvency application was filed. And on 10th May 2023, this the NCLT special bench, comprising of the Honorable President Justice Ramlingam Sudhakar and Shri Ellen Gupta, Honorable Member, Technical as the quorum. They heard the arguments. The application was filed on 2nd May, and within a short span of 1 week, the decision was delivered. The insolvency application was admitted. So this was a Section 10 application. Now let's have a look at some of the facts and surrounding circumstances. So basically, what are the surrounding circumstances? If we look at the brief history of Go Air. Now, in November 2005, Go Air was founded by Jahangir Wadia as a low-cost airlines. On 4th November, Go Air commenced its operations with its inaugural flight between Mumbai and Ahmedabad. And during 2005 to 2010, Go Air expanded its route network within India and added destinations Delhi, Chennai, Bangalore, Goa, Calcutta. Then in 2011, Go Air placed a significant order for Airbus A320 Neo to improve operational efficiency and reduce the fuel consumption. Then in 2014, Go Air became the fifth largest airline in India in terms of market share. In 2016, airline announced its plans for international expansion and received approval from the government to fly to international destinations. In 17, Go Air launches its first international flight from Mumbai to Phuket, Thailand. Then in 2018, the airline announces the conversion of a portion of its A320 Neo order to the larger A321 Neo aircraft to support its growth strategy. In 2019, Go Air celebrated its 14th anniversary and reached a milestone of carrying over 80 million passengers. So till here, everything is going as per a well-planned business operation. There is growth and there is a well-planned out strategy which is being executed as well. However, in 2020, the COVID-19 pandemic severely impacted the global aviation industry, including Go Air. Airlines suspended operations for a few months and certainly faced financial challenges. In 21, Go Air rebranded itself as Go First Airlines and planned to go public with an initial IPO to raise funds for its expansion and debt reduction. Now, so what happened? What was the background? So, what was the immediate background for filing the insolvency application? So, certainly, we have seen that COVID created challenges. And apart from that, these new engines, these new aircraft, which had some engines which were to be supplied by Pratt and Whitney and serviced as well. So, there was an issue with the engines wherein the aircraft could not fly. So just immediately to this insolvency filing, the corporate applicant had filed emergency arbitration against Pratt and Whitney before the Singapore International Arbitration Center, wherein the emergency arbitrator passed awards dated 3rd February 23 and 15th April 2023, directing Pratt and Whitney to supply 10 serviceable engines by 27th April and 10 serviceable engines each month till December 2023. And the copy of the same was also annexed in this application. And the CD further stated that P&W fails to comply with the aforesaid orders, for which the applicant has already initiated enforcement proceedings against P&W in Delaware, US, as well as other relevant jurisdictions where engines are located. So this is the genuine issue with respect to the business. Now, what is the default? Now, the CD claims to have committed a default of rupees 2660 crores towards the aircraft lessors and 1202 crore towards its vendors. As on the date of filing of application, the CD did not default towards the payment of dues to FC. However, on 4th May, it committed a default of rupees 11 crores towards interest dues to FC. So there were outstandings, there were default towards the lessors, and these were continuing since some time, since over 6 months. But there was no outstanding, no default committed towards FC. Hence, Go Air was not NPA, and hence the Section 10 application. I mean, and there was no at that time there was no outstanding or default towards the FC. But then during this time, they were apprehending to commit a default, and ultimately they were unable to meet their obligations towards the FC, and their default was committed on 4th May. So the request was that the corporate applicant will lose all its assets if protection under the moratorium under section 14(1) of IBC is not granted to the corporate applicant on an immediate basis. So these are some of the initial facts why the application was made, and the main reason was that it was facing financial distress as a result of inherently defective engines supplied by Pratt and Whitney, and because of those engines some aircraft could not fly, which was causing a huge loss. And of these 54 aircraft, 28 were grounded because of defective engines. So practically more than 50% of the aircraft are grounded, and 26 are operational. The resolution professional. So then. So what were the arguments? So during the when the insolvency application was filed, the operational creditors, the airline leasing companies, they opposed the present application on the ground that they wish to file an application under section 565 of IBC. And they also contended that before adjudicating the section 10 application, it is necessary that a notice be issued to the creditors, giving them an opportunity to object to the present application. And the lessors, objecting the insolvency application, relied upon a case which was passed by the Honorable NCLAT, Krish Realtek Private Limited, and which mentioned that the rules of natural justice must be followed, and hence the notice must be issued. However, the case could not be relied upon in these present circumstances because that case was for a pre-pack insolvency, wherein the consent of 66% of creditors was required. Hence, this Krish Realtek case was not a good case which could be referred. Uh, in any case, the NCLT considered that the when these contentions are being made by these operational creditors, that is the leasing companies, this means that they are already submitting their arguments. So now there is no need for giving the notice. They have already been heard. As far as application under section 65 is concerned, that is the application insolvency application filed to commit fraud upon the creditors. Well, there is no requirement to first adjudicate a section 65 application and only then consider the section 10 insolvency admission. So the NCL team said that you are most welcome. They can go ahead with, if they want to file section 65 application, they can go ahead. It is a remedy available under the law. So with this, the Honorable NCLT order was that application of CD Go Air is admitted, and as an necessary consequence, the moratorium in terms of section 14(1) A, B, C, D was declared and the prohibitions imposed. Then IRP was appointed and directed to take charge of the CIRP of the CD with immediate effect. And IRP was directed to take steps as mandated under the IBC, specifically under sections 15, 17, 20, and 21 of IBC. And IRP will ensure to take all necessary steps, including the execution of the arbitral award, to keep the CD as a going concern and run its services smoothly. The IRP will also ensure that retrenchment of employees is not resorted to as a matter of course. In any event, any such decision event should be brought to the attention of the adjudicating authority. So this is the NCLT decision, and then the IRP published a public announcement on 13th May and invited claims from all creditors of Go First. So this was the NCLT order, and the only arguments or challenge was that notice is not given and the principles of natural justice were to be followed. However, when the leaseors are already arguing in the NCLT, the requirement of giving a notice or the requirement of principles of natural justice does not arise because they're already given the opportunity to argue their case. And as far as their objection, uh, the the right to file application under section 65 is concerned, they were free to file the section 65 application, and there is no precondition that the first section 65 application should be adjudicated. Only then the insolvency application under section 10 could be considered. So section 65 application could take some time, maybe 1 year, 2 year, whatever time, and under the peculiar circumstances there was no reason to wait further. So this was the order provided by NCLT, and then appeal was filed in the Honorable NCLAT, and appeal was filed by the leaseors SMBC Aviation and GY Aviation Lease 1731. Now, again, the major focus on arguments was uh, that Section 65 application must be decided, and only upon determination of Section 65 application, that is, there were allegations of fraud, the CD or the corporate applicant wanted to commit fraud upon the leaseors by taking possession, and the intentions were malified. However, the Section 65 application was still not filed and might not have been filed till now. So the order was that of the NCLAT was that Section 10 application admission order is upheld of the NCLT, and appellants are at liberty to file appropriate application under Section 65 with appropriate pleadings and material, and adjudicating authority while considering this application shall not be influenced by any observations made in this order. Now, Section 65 is, involves fraud, and there is a different test to identify whether the intentions were malified and fraudulent, and then it has to be decided on those grounds. Then the third point is the appellants as well as IRP are at liberty to make appropriate application before the adjudicating authority for declaration with regards to applicability of the moratorium on the aircrafts with regards to which leases in favor of the CD were terminated prior to the admission of Section 10 application, which application needs to be considered and decided by the adjudicating authority in accordance with the law. Then the appellants and the IRP are also liberty to make appropriate application under Section 60, subsection 5, with regard to claim of possession and other respective claims of both the parties relating to the aircrafts in question, which needs to be decided by the adjudicating authority in accordance with law. Now the question is that the order of NCLT was not interfered into. However, uh, then what happened? A case was writ was filed in the Delhi High Court, and writ was filed by the Executor Investments Aircraft versus Union of India. So the story is that on 2nd May, the insolvency application under Section 10 was filed by the Go Air, and on 3rd May, the leases were cancelled, and this writ was filed in the Delhi High Court. So what they did was, now we are looking at the specific airline insolvency. Now, airline insolvency, or the multiple laws which are available for the aircrafts. Now, aircrafts are governed by the Cape Town Convention, and Cape Town Convention is an international convention, international law, which applies to aircraft. Now, India is a party to the Cape Town Convention, and as early as the earlier case of 2015, the earlier case was Avas Ireland versus DGCA. In this case itself, Honorable Mr. Justice Rajiv Shakdar has recognized that India has agreed, has adopted, and ratified the Cape Town Convention, and accordingly, the aircraft rules are formed, and they incorporate the terms, and those terms are that leasers can rescind. So when the leasers feel that there is some sort of a default, they will have an option. They can approach either the insolvency courts, or they can take recourse to rescind or cancel the lease and take possession of the aircraft. So this option is available, and hence, even in that previous case, the this was a case of SpiceJet. So the request was made to the DGCA to deregister the aircraft and give it to the possession of the lessors. So, as far as the aircraft are concerned, they are subject to the Cape Town Convention, and India being a party, the relevant aircraft rules incorporate that a choice will be, that an option is available to the lessor, that upon a default committed by the airline company, the airline lessor, can cancel the lease agreement and request to take possession. So what they will do is, they will make a representation, make a request to the DGCA, because DGCA is the nodal agency which is mandated to comply the Cape Town Convention in India. So the DGCA then will deregister the aircraft so that the lessors can take them in their possession. So the case of the airline, the case of the lessors are that they have the right under the Cape Town Convention, and that right and the lease agreement give them right to cancel the lease agreements upon default being committed by the airline, and they make a request to the DGCA, and the DGCA will deregister the aircraft and give them to the possession of the lessors. So on 3rd May, the lessors cancelled the lease agreement and made a request to the DGCA to deregister and put them in possession. Under the rules, the DGCA is required to take decision within 5 days. However, uh, the DGCA did not decide their application within 5 days, because it was informed that an insolvency application was already filed. So before the DGCA could deregister the aircraft and give them to in the possession of the lessors, the NCLT declared its order and imposed a moratorium upon the aircraft, so that now the DGCA uh, could not deregister the aircraft and give them in the possession of the lessors. Now this writ is filed, so because the DGCA did not decide, and DGCA is mandated to comply with the international law which governs the aircraft. So the case was filed that DGCA should deregister the aircraft, and because it is uh, because it is the repository, because it is mandated to manage the Cape Town Convention and apply it in India, it should consider the request of the leaseors. So the for the aircraft, the law that is applicable in India is usually this Cape Town Convention. Uh, but the thing is that India has adopted the convention. However, now there is a new legislation, which is the aircraft convention bill, which was drafted in 2022 last year, but which has not yet been introduced into the parliament. So now the the law that is to be applied by the DGCA is the aircraft rules, which go back to 2015. Now DGCA, so now this writ has been filed in the Delhi High Court, where the uh, petitioners, that is the leaseors wanted that they should get access to the aircraft, because now the situation is, and we can read in the newspapers as well, that some aircraft parts are being stolen, and even now the NCLAT has considered that the leaseors should get access to the aircraft, and they can check that the aircraft are not damaged. So in this Delhi High Court, when the writ was filed, this 5th July order, the following directions were passed. The petitioners, their employees, agents, officers, representatives shall be permitted by the respondent, DGCA, and the appropriate airport authorities to access the airport where the 30 aircraft are parked, inter alia to inspect their respective aircraft. The petitioners, employees, agents, officers, and representatives, these are the leasers, shall be permitted to carry out inspection and all maintenance tasks of the aircraft, its engines, and other parts and components of all 30 aircraft at least twice every month until the final disposition of the writ petitions. The respondent, Go Air, its directors, employees, agents, officers, and representatives of the IRPRP or any person acting on their behalf are hereby restrained from removing, replacing, taking out any accessories, parts, components, or spares, etc., or any relevant operational or other manuals, record, documentation from any of the 30 aircraft, except with prior written approval of the leaser of such aircraft. And then the DGCA shall also permit the aircraft to RP to carry out the mandatory maintenance engine runs of the aircraft until its deregistration. So these directions are passed qua the interim applications and shall not impact the merit of these petitions. So this was again an interim order, interim direction, interim order. The final, so against this order, appeal was filed in the division bench of the Delhi High Court, but that so this order of the single judge of Delhi High Court is still continuing. Appeal was filed in the division bench, but it was dismissed. And similarly, an appeal was filed in the Supreme Court by the basically by the RP and the airline, which was not considered. So now the things that stand is that the petitioners, which are the airline leasers, the leasers have do not have yet the possession, but they can inspect, and virtually they are going to manage or maintain the aircraft till further orders. Right. So before I move further, I want to ask if there are questions, because this is, I would want to take some more time to discuss the relevant rules and the case law on this point. So, with the help of the previous case, I am going to explain to you the process in case of airlines. What is the usual process and the powers and the rights which are available to the leasers in these airline lease agreements. So, there is an irrevocable deregistration power of attorney, and there is an irrevocable deregistration and export request authorization IDERA. And this basis of this IDERA, so this is this irrevocable deregistration and export request authorization IDERA. So this agreement is executed between the airline and the leaser, and this IDERA gives right. This is registered. This has to be registered with the DGCA, and this IDERA gives right to the leaser to terminate the lease agreement in case of default committed by the airline, and then basis this IDERA, request is placed with the DGCA to deregister the aircraft so that the leaser can take back the possession of the aircraft. So now we need to look into what are the interesting aspects of the law. So now this is the convention which governs the aircraft. The provisions of the convention, the Cape Town Convention, the protocol, and the aircraft rules. Right. So the framework of the convention is the preamble of the convention, that is the Cape Town Convention, suggests that it seeks to facilitate the acquisition and use of mobile equipment of high value and economic significance. In other words, it encourages and facilitates asset-based financing. While doing so, it seeks to recognize the interest in such equipment and protects the same universally. The convention, thus, in effect, provides a legal architecture for international interest created in such equipment. For this purpose, the convention, that is the Cape Town Convention, has put in place an international registration system. The idea being to provide uniformity, certainty, and predictability in commercial transactions involving high financial stakes. The convention, while protecting the interest of the creditors, seeks to give due deference to the national legal regime, that is, the municipal law of the contracting state. Therefore, logically and quite clearly, the convention does not affect national legal regimes which concern and are relatable to criminal conduct and tortious liability. The convention also does not appear to impinge upon public law issues. The thrust of the convention is to make available private finance for mobile equipment to persons situated in contracting states. The convention, as currently positions, deals with airframes and aircraft engines, helicopters, railway rolling stock, and space assets. It is the protocol which is industry specific, which provides the necessary time framework vis a vis the concerned industry. Therefore, the aircraft protocol, which is referred to for the sake of brevity as the protocol, both supplements and wherever necessary modifies the convention, which is more generic in nature to the extent necessary for the purposes of the aircraft industry. So the Government of India has lodged 6 declarations under the convention and 5 declarations under the protocol under various forms. Now, Article 11(1) of the Convention provides that the parties may agree in writing as to what would constitute an event of default or otherwise give rise to rights and remedies under Article 8 to 10 and 13 of the very same Convention. In each of the lease agreements, it is inter alia provided that leasee's failure to make payments of the lease rent would constitute a termination event or an event of default. So, uh, Article 8 to 10 and 13 of the Cape Town Convention provide the right. And usually in the lease agreements, in all the lease agreements, it is provided that the lessee's failure to make payment of the lease rent would constitute a termination event or an event of default, and which is invariably there in all the lease agreements and which is also there in the agreement between Go Air and their leasers. In these circumstances, the remedies available to a leaser are those which are provided in Article 10 of the Convention. Article 10 provides that if the event of default uh, it has occurred under a leasing agreement as envisaged under Article 10 of the Convention, then subject to any declaration that a contracting state may have made under Article 54, the leaser would have the right to either terminate the agreement and take possession or control of any object to which the agreement relates, or could apply for a court order authorizing or directing either of such acts. So the remedy is that the leaser would have the right to either terminate the agreement and take possession or control of any object, or could apply for a court order authorizing or directing either of these acts. So basically, what the leasers do then Article 54 Clause 1 of the Convention provides that contracting state may, at the time of ratification, acceptance, approval of, or accession to the protocol, declared that while the charged object is situated within or controlled from its territory, the chargee shall not grant a lease of the of the object in that territory. Clause 2 of Article 54 specifically provides that the contracting state shall, at the time of ratification, acceptance, approval of, or accession to the protocol, declare whether or not any remedy available to the creditor under any provision of the convention which is not there expressed to require application to the court may be exercised only with the leave of the court. So, under Article 54(2) of the Convention, the Government of India has filed in Form number 13 with the following mandatory declaration. Any and all remedies available to the creditor under the Convention which are not expressed under the relevant provision thereof to require application to the court may be exercised without court action and without leave of the court. This would mean that in its declaration filed under the convention, the government has made it categorically clear that unless the remedy available to the creditor under the convention requires application to the court, the same can be exercised without court action and without the leave of the court. This is important in the context of Article 19 of the protocol, as would be evident from the discussion set forth. So in these circumstances, the leaseors are entitled to approach a court and seek advance relief pending final determination of Article 13 of the Convention. Thus, the relief that the petitioners can seek ordinarily would be: A. Preservation of the object and its value. B. Possession, control, or custody of the object. C. Immobilization of the object. And D. Lease or, except where covered, management of the object and income therefrom. So these are the clauses and conditions, the right which are provided under the Cape Town Convention, and the government of India has adopted it. Now the issue is that some of these reliefs run contrary to some of the existing laws, some of the existing municipal law, because reliefs will be required from the court, specific relief. So some it will be in contravention to the Specific Relief Act, and the option of default provides the leaseors to terminate the lease and also to seek possession of the aircraft. Now, an event of default is also governed by the Insolvency and Bankruptcy Code. Now, IBC Section 238 is an overriding law which provides that IBC will override any other law. So, in case of this conflict of law, now the government's obligations under this convention, the government has adopted, and in a sense, the IBC is a later law which has been drafted in 2016. So IBC has a overriding effect.
What is this behavior, Aditya?
Sorry, is there a question? Someone?
I will give it to you only, madam.
Was just wondering if there are any question, any observations. Please let me know. Right. So this is the existing law which was applicable till IBC came into force. Now the aircraft leasers get the right to cancel the lease, which they have done, and so this is the law, the Cape Town Convention actually, and that is what we are reading. What are those remedies available to the leaseors? So Article 9 of the protocol confers an additional right on the creditor to procure deregistration of the aircraft objects and the export and physical transfer of the aircraft object from the territory in which it is situated. For so Article 9 of the protocol provides an additional rights to the creditor, that is the leaseor, additional right which is deregistration of the aircraft and export physical transfer of the aircraft object from the territory in which is situated. So, clause 4 of Article 13 says that registry authority, which is the DGCA, and other administrative authorities in the contracting state shall expeditiously cooperate with and assist the authorized party in exercise of the remedies provided under Article 9. Therefore, if a contracting state has made a declaration pursuant to Article 30 of the Act, and if IDERA is issued by the debtor, then on the force authorized person or its certified designate triggering the remedy under Article 19.9.1, having regard to the applicable aviation safety laws and regulations, the same will have to be honored by the registry authority and other administrative authorities of the contracting states. So the IDERA was issued by the debtor, which is the corporate debtor, the Go Airlines, and hence the creditor, which is the leasing company, can make a request to the registry authority, which is the DGCA, and DGCA will have to honor this IDERA request to deregister the aircraft. In the present case, the declaration has been filed by the Government of India in Form 27 under Article 30. So Article 9, modification of remedies provisions. So in addition to the remedies specified in Chapter 3, the creditor may, to the extent that the debtor has at any time agreed and in the circumstances specified in the chapter, procure the deregistration of the aircraft and procure the export and physical transfer of the aircraft object from the territory in which it is situated. The creditor shall not exercise the remedies specified in the preceding paragraph without the prior consent in writing of the holder of any registered interest ranking in priority to that of the creditor. So the registry authority, which is that is the DGCA, shall, subject to any applicable safety laws and regulations, honor a request for deregistration and export if. So what are the situations in which the DGCA shall recognize and honor this request for deregistration? The circumstances are: first, the request is properly submitted by the authorized party under a recorded irrevocable deregistration and export request authorization, and the authorized party certifies to the registry authority, if required by that authority, that all registered interest ranking in priority to that of the creditor in whose favor the authorization has been issued have been discharged, or that the holders of such interest have consented to the deregistration and export. So the what is required obligations on the part of the chargee or the lessor, that is the aircraft lessor. The chargee proposing to procure the deregistration and export of an aircraft under paragraph 1, otherwise than pursuant to a court order, shall give reasonable prior notice in writing of the proposed deregistration and export to interested persons specified in Article 1MI 1 and 2 of the Convention, then interested persons specified in Article 1M3 of the Convention, and then so the commentary is: what is the effect of these provisions of the protocol? So the Cape Town Convention and the Aircraft Protocol. So clause 5 of Article 9 of the protocol casts an obligation on the registry authority in the contracting state, which is the DGCA, to honor a request for deregistration and export in the following two conditions. First, the request made is properly submitted by the authorized party under a recorded IDERA. And secondly, the authorized party certifies to the registry authority that all registered interest ranking in priority to that of the creditor in whose favor the authorization has been issued have been discharged, or that the holders of such interest have consented to the deregistration and export. So, what are these rights? Now the question is, what are the claims which will have priority? If airline leaser, aircraft leasing company, the operational creditor wants to take possession and take away this aircraft, they will have to take care of the claims. So, what are those claims? So, those claims are liens in favor of airline employees for unpaid wages arising since the time of declared default by that airline under a contract to finance or lease an aircraft. Then liens or other rights of an authority of India relating to taxes or other unpaid charges arising from or related to the use of that aircraft object and owed by the owner or operator of that aircraft object and arising since the time of a default by the owner or operator under a contract to finance or lease that aircraft object. And liens in favor of repairer of an aircraft object in their possession to the extent of service or services performed and value added to that aircraft object. So this means that the leaser cannot just take away the aircraft and without any further charge. So these interest will still have priority. So A provides for the unpaid wages, employees, and liens or the rights of authority or taxes. So these will have to be taken care of by the lessor before they take possession and export the aircraft object. So this is mentioned as far as the power of high courts to issue writs and issue a writ of mandamus under Article 226. This is a power which is certainly there with the high courts. Now, Rule 30 was amended of the aircraft rules. This is the aircraft rules of India, and relevant amendment brought about in Rule 30 by notification dated 9 February 2015, issued by the Ministry of Civil Aviation. So the amendment was made. The registration of an aircraft registered in India to which the provisions of the Cape Town Convention or Cape Town Protocol apply shall be cancelled by the central government as provided in the Cape Town Protocol if an application is received from the IDERA holder prior to expiry of lease along with the original notarized copy of the IDERA and a certificate that all registered interest ranking in priority have been discharged or the holders of such interest have consented to the deregistration and export. Then provided that the deregistration of an aircraft by the central government under sub-rule 6 or 7 shall not affect the right of any other entity or any intergovernmental organization, so on. So a bare reading of the aforesaid shows that with the insertion of sub rule 7 in rule 30, the doubt as to whether the DGCA had any discretion in the matter has got removed. Now, upon the creditor fulfilling the conditions prescribed in clause 1 and 2 of sub rule 7 of rule 30, the DGCA is mandatorily required to cancel the registration. Therefore, so basically, this was the previous decision, but apparently the interpretation is that this sub rule 7 of rule 30 of the aircraft rules, the DGCA does not have any discretion upon the creditor fulfilling the conditions prescribed in clause 1 and 2. The DGCA is mandatory to required to cancel the registration. So further observations, if you read here, uh, a special meaning shall be given to a term if it is established that the parties so intended. An international convention, that is a treaty, is required to be interpreted in good faith in accordance with the ordinary meaning given to the terms of the treaty in their context and in the light of its stated object and purpose. With the insertion of sub rule 7 in rule 30 of the aircraft rules, uh, in this case, it is provided the position with regards to the manner in which the DGCA has to proceed once a creditor seeks recourse to the remedy under Article 9 of the protocol has acquired greater clarity. So another interesting and very commercial observation, that is another aspect which has to be kept in mind while dealing with such matters is a court not to proceed in a manner which retards funneling of much needed private finance for business transactions in India. This is not to say where the legitimate legal rights surface under municipal law, the law would ignore them. So basically, court ought not to proceed in a manner which retards funneling of much needed private finance for business transactions in India. So this is a very well made observation. And as far as the arguments on public interest are there, although this was an old case, but the observations are very relevant, that deregistration or repossession of the aircraft object would impinge upon public interest. However, observation is that there is much, there is as much, if not more, public interest in ensuring that treaty obligations are honored and that parties adhere to their respective contractual obligations. The very fact that India has ratified the convention and protocol gives rise to the presumption that it has been done in the larger public interest as against a narrow interest of one particular airline. Right. So this is on the uh, Go Air insolvency case and the law which is applicable on airlines. So, which is as on today. However, there are certain uh, conflicts, and those conflicts needs to be resolved. The case is going on in the Delhi High Court, and very soon a decision is likely to take place. So, with this, I would like to open this floor for questions. If there are questions on this case, before I move on to the next case.
Sir, actually, I have a small doubt in this.
Yes, please.
Sir, actually, this petition got admitted without notice under Section 10 petition, actually.
Yeah.
This insolvency petition actually admitted without giving any notice to the parties. So, according to us, is it not necessary to issue the notice under Section 10 petitions as far as the things are concerned? Because it's a primary, everybody should be heard, actually. This is the fundamental rule of the law, which we think.
So, see, ultimately, when you read Section 7, Section 7 does not require any mandate of giving a notice. And in Section 9, the requirement of giving a notice is that a demand notice must be served. Similarly, in Section 10, there is no requirement of giving notice because
yes, sir.
There can be n number of creditors, n number of players. Similarly, in case of financial creditors, there can be n number of financial creditors. So we have to understand the concept of giving notice. It is not practical or feasible. So first of all,
yes, sir. Section 7 petitions, usually NCLT issues the notice to the corporate debtor. Then after hearing the parties, they admit the petition. That is the thing, actually, under Section 7. As far as the Section 7 is concerned also, both the situation, there is NCLT in this present case, we have seen first time in the history when NCLT actually has not issued a notice, simply admitted the petition without issuing a notice. That means Section 10, which actually we understood, under Section 10 IBC, there is no need of notice to initiate.
Actually, so you are missing the point. The point is not notice has to be served, but to whom it has to be served. In case of Section 9 application or Section 7 application, opposite party is the CD. There is only one. Okay,
Correct.
so NCLT can issue the notice. Although the code Section 7 does not provide for a Section 7 applicant to give a notice or the NCLT to give a notice for representing. However, it is only one party. So NCLT can give notice.
Yes.
Whereas in Section 10 application, there can be n number of creditors, there can be thousands of operational creditors, there can be hundreds of financial creditors. So it is practically not possible to give notice. So that is why Section 10 does not provide a mandate for giving a notice.
That actually, most of the time, earlier whenever we see the Section 10 petitions, mostly major financial creditors, the NCLT issued the notices before admitting it. But this is a unique case. First time we have seen when without issuing notice to the major financial creditor, the petition got admitted. That is the main thing. No issues. I mean, we understood the point actually. That's it. Anyway, thank you, sir. Thank you. Thank you.
Thank you, Mr. Khatri. Anybody else? So in any case, the issue is not of serving of notice or issuing of notice. The question which was raised of following of principles of natural justice, and when the leasers were allowed the representation, it was held that the principles of natural justice have been satisfied. Okay, so what I have discussed with you is, so you are you are all insolvency practitioners. However, the role of this session is the anatomy of a case law. So case law does not always mean that it has to be related to the insolvency matter only, but a case which is, let's say, Go Airline. So Go Airline is being argued in NCLT appeal at NCLAT, then a writ petition is in the Delhi High Court. So what is the role of the Delhi High Court, and what is the role of the DGCA, and what is the alternative law available for the resolution of airlines, uh, let's say, situation? We should not call it insolvency, but the law applicable or the law governing the airlines, right? So the law governing the airlines is the Cape Town Convention, and India has agreed to it. And the lease agreement, the IDERA is signed, and IDERA is registered with the DGCA. And when the leaseor makes a request to the DGCA is mandatorily to recognize and give effect to this request of the leaseor. And because the DGCA did not give effect to the request of the leaseor, the writ petition has been filed by the leaseors against the DGCA. So that case is continuing, and this is what the stage is till now. So I have explained to you the Cape Town Convention, the bill, which is the Cape Town Convention bill, the aircrafts, the new act. Okay, so the bill is there in the draft form. However, it has not yet been enacted. So after it is enacted, then now, similar to the RERA will be taking care of the issues relating to the real estate, so that aircraft rules or this Cape Town Convention will be the law that will be regulating the aircrafts. All right. So the next case that I have is, I was just wondering, can we take just a short break of 5-10 minutes?
Sure, sir.
So just allow me 5-10 minutes. We'll just rejoin in 5-10 minutes. Okay, so welcome back. Sorry, I just had to had a all right. So please let me know if you are able to watch the PPT and I'm easily available, accessible to you. You can hear me properly.
Yes, sir.
So
Both okay.
this is a new concept which is a project-wise resolution. So the IBC does not the Insolvency and Bankruptcy Code does not provide for the project-wise resolution or some special provisions for the real estate sector. However, uh, so the problem that was faced was that the insolvency application is filed against a company, and once the insolvency application is admitted, the resolution professional IRP takes over the entire company. However, as far as the real estate projects are concerned, one company may run several different projects, and issue may not be with the company as a whole, but may be with some projects. So it was possible, and it is certainly possible that a company like Supertech may have issues in some projects, but some projects may be running fine. So if the projects which are running fine, they're also taken over by the IRP, that creates a huge symmetry, and issues will crop up regarding the management and administration. So this case is the India Bulls Real Estate Construction versus the Ramkishore Arora case. And the Supertech had taken loans from banks, Union Bank and other banks, and then when the Supertech committed default, insolvency application was filed by the banks, by the FC. So the Section 7 application was admitted by the NCLT in March 2022. Now, Supertech is a renowned real estate developer in the NCR, and Supertech has around 38,000 home buyers, and out of them, homes were delivered to 27,000 people. As many as around 11,000 homes are yet to be delivered, and among them, over 70% construction is complete with respect to over 8,000 homes. So NCLT admitted the Section 7 application and directed initiation of the CIRP of the CD, and interim resolution professional was appointed. Aggrieved by the order of NCLT, the promoter, the suspended director of the CD, filed an appeal before the NCLAT. NCLAT issued interim directions for the constitution of Committee of Creditors for Eco Village Project 2, and only the said project to be completed with assistance of ex-management, whereas other projects apart from Eco Village 2 were ordered to be continued as ongoing projects. The division bench of Justice Maheshwari and Sanjay Kumar justices upheld the NCLAT's order for the project-wise resolution, and said that if committee of creditors would be constituted for Supertech as a whole, it would cause hardships for the home buyers. The Honorable Supreme Court held that the NCLAT had adopted a particular course while observing that the project-wise resolution may be started as a test to find out the success of such resolution. The result of the directions of the impugned order was that, except Eco Village 2 project, all other projects of the CD were to be kept as ongoing projects, and the construction of all other projects was to be continued under the supervision of the IRP with the ex management, its employees, and workmen. Further, the court said that if at the present stage the COC was ordered to be constituted for the CD in displacement of the directions of the NCLAT, it was likely to affect those ongoing projects and thereby cause immense hardship to the home buyers while throwing every project into a state of uncertainty. So these are the genuine concerns, and because of some of these interesting cases, if you remember in the January 2023 MCA discussion paper, they have discussed about some innovative aspects like project based insolvency of the real estate companies. Now, with the real estate companies, there are several innovations, and the IBC, as you know, is a principle based law, and it was drafted as a skeleton act. So the skeleton act means that there is a bare principles, and the IBBI is drafting detailed regulations, while the ministry, the MCA, is drafting the rules. So ministry is notifying the rules, and as and when the situation arises, the insolvency board, which is the regulator, is drafting detailed regulations. Now, although the IBC does not provide for any such innovation with respect to sectors, real estate sectors, but we have seen that sectors have their specific issues. Uh, so through way of this judicial innovation, which is initially the NCLAT. So NCLAT had previously uh, given this reverse CIRP as well. So there are certain innovations which have taken place with respect to the real estate sector and declared by the NCLAT. And continuing with the reverse CIRP, and which the reverse CIRP basically means that the management, so in the interest of resolution to keep the costs down, the corporate debtor management, the corporate debtor may not be willful defaulters. They are best known to, they know how well to manage these projects. If there is a crunch of liquidity, the liquidity can be infused and the projects be completed in the interest of the stakeholders, which are the home buyers. So the prime interest is that the home buyers must get their flats, because the if they are sold, that is the projects are sold to in the market in resolution plans, it may not be very cost effective. So the best sort of a resolution is that with less of cost and streamlining of management with some supervision provided by the IRP or the RP, the projects must be completed and the home buyers must be delivered the flats. So another innovation which has been coined, which has been devised by the NCLAT, is the project-wise resolution. So instead of putting the entire company, the corporate, into insolvency and appointing one IRP to manage the entire real estate company's set of projects, rather they have found it suitable. Let's continue and let's discuss and dissect on a case to case basis, that is projects. Dissect all the cases and consider which cases require the resolution and which cases can continue under the previous management. So now here the observations of the Supreme Court are also very valuable, and which basically has upheld the detailed observations of the NCLAT. So NCLAT is the best in the best position to look into the factors. It has heard the various parties, and found it suitable to provide for something like a project. So the result is that except for the Eco Village 2, all other projects of the CD were to be kept as ongoing projects, and the construction of all other projects was to be continued under the supervision of the IRP with their ex-management, its employees and workmen. Further, the court said that at the present stage, if COC was ordered to be constituted for the CD in displacement of the directions of the NCLAT, it was likely to affect those ongoing projects and thereby cause immense hardship to the home buyers while throwing every project into a state of uncertainty. So it is with effect to continuing of the existing scenario. So whatever is the existing directions in place, the existing role of the IRP and the ex management is in place, that has been continued, and that will create better synergy so that the efficiently these the resolution, that is the home buyers can get their flats. So any questions on this topic of project wise insolvency? So I hope I'm audible and the PPT is also visible.
Yes, please.
Yeah, so it's now.
Sir, in project-wise resolution, that means a resolution for all the projects will be different. That means some projects may be liquidated, or some projects, for some projects, there may come some plan. What is the meaning of project-wise resolution?
Right. So project-wise resolution here basically means that the uh, so okay, so let's go back to the reverse CIRP. In case of real estate insolvency resolution, in case the adjudicatory authority feels that the existing management is existing management has not been conducting malafide activities, okay, or is more or less genuinely interested in the real estate project. However, because of certain circumstances, as we have seen in the case of Go Air, that the main problem was the defective engines by Pratt and Whitney and the COVID. So COVID has caused lots of issues in lots of businesses. So there are, even the BLRC also talks about two types of issues which cause stress. So stress may be caused due to business aspects or due to the financial aspects. Now, in case the stress is caused purely by financial aspect, that is, there is a liquidity issue, and which is beyond the purview of the management, and management was more or less efficient, and they were not malified in their intentions. So the reverse CIRP can be ordered where the resolution professional is appointed, but the existing management will continue, and the IRP or RP, with along with the existing management, will conduct the resolution. So in this case, the project is not sold as a in a resolution plan, but it is continued as a going concern, and with the association of the IRP and the existing management, and the bankers financiers provide the financing, it is completed. So it is not sold, there is no resolution plan as such.
No, sir, my point is not that. My point is that, sir, if a corporate debtor has 5 or 7 projects, one at Delhi, one at Mumbai, other at Kolkata. Suppose Delhi project is a greenfield project, and Kolkata project is a totally almost completed project. So if we take all the CIP as a whole, that means the project which is already completed, home buyers at Kolkata, they will face the problem. So perhaps taking that into consideration, that project-wise resolution plan, that concept has been developed. So my point is that if that a project is already almost completed, so in that case, will it be considered completely separate? So that can be, for that resolution can be done. And for a greenfield project, a resolution plan may not come at all. Sir, why I am asking? One more company, that is Unitech, that is also known to everybody. That is also undergoing same type of problem, and but that is not under CIP. So, so that's why I'm asking, what is the meaning of project-wise resolution?
Yeah, so exactly project wise resolution is that the so for real estate we understand now that it is not essential that there will be a resolution plans will be invited from external people. The existing management and the IRP may also continue to complete the project by providing
Sir,
financing.
existing management doesn't now, because the company has gone into CRP. Existing management is not there, or they do not have money to run the show. So that's why this position is there. So in this case,
Yeah.
I'm asking because they have diverted money. They might have diverted money from one project to another project. So people at the project where progress has not been completed, they may complain that our money has been diverted to other project. So how to deal with that? How it is dealt with? That is my question, sir.
Exactly. So the in case of project wise, as we have seen in this case of Supertech, now Supertech is a case, and there are now some more projects for which the project wise has been allowed. But the NCLT or the NCLAT, they have to look into whether the project wise can be feasible or not. First thing is the feasibility has to be looked into, and as you have very rightly pointed out, the existing management does not exist. In this circumstance, for that particular project, a resolution plan will be invited. And in case a particular real estate company has a project which is nearing completion, so that will continue. So with the IRP, in association with whatever the existing management is there for that project, they will strive to continue that project so that it is completed. And for those projects in which there is a substantial need for expertise and the management, existing management is not there, for them resolution plan certainly will be invited.
Yes.
Right, any other questions?
Sir, unless there is project-wise balance sheet, then how the project-wise resolution is possible?
Sir, I'm sure that all of this will be looked into when the Honorable NCLT or NCLAT is approving the same. So you are right, you are the RP or the IRP, and you will have to look into whether circumstances arise that the different projects can be managed independently. So it has to be feasible. So first, feasibility check has to be there. Balance sheet or the finances are so intermingled and the management is so intermingled that project-wise resolution is not possible, then it is not feasible. So yes, you are right. The business decisions are taken to be taken by the IRP and the COC. So this is a business decision that you can consider along with the COC, whether the feasibility exists, whether the circumstances exist or not, and then accordingly the application may be made. Okay. So the next case is, this is a case of again interesting case, the delivered by the Honorable Chief Justice, Justice Ramlingam Sudhakar. This is partial resolution and partial liquidation. So this is the Hindustan Photo Films, Chennai, and this is the case that they approved a resolution plan for resolution of true freehold assets of Hindustan Photo Films by way of a scheme of demerger. An NCLT, by way of a separate order, also commenced liquidation proceedings against HPF with its remaining assets, which were treated as the excluded assets by the Committee of Creditors. So, according to the NCLT order, while approving the resolution plan, the HPF COC passed two separate resolutions. First, for approval of the resolution plan for acquisition of the freehold assets and liquidation of HPF along with the remaining assets, because no viable resolution plan was received for the remaining assets. So this is a proposal proposed in the new MCA discussion paper as well. So when the resolution plan for a company as a whole is invited, sometimes there are some assets which are the resolution, the potential resolution applicant are not interested. And the resolution applicant may be interested only in few assets. So, so the resolution plans are now being invited specifically. Okay, so there are particular assets, and only for those assets the resolution plan is invited, and for those assets for which there is no resolution plan, they are hived off and they are liquidated. They are basically liquidated. So, so this is a very innovative way where the resolution has been conducted. So this order was pronounced on 31st March 2023, and this is in the matter of Hindustan Photo Films, and the resolution professional is CAM Suresh Kumar. So the application, this case was filed. So this is basically the application has been filed under section 30 subsection 6 and section 31 of the IBC for approval of the resolution plan and the following relief. Pass order approving the resolution plan which was approved by the COC as per sections 30 clause 6 and 31, and consequently pass an order by waiving the requirements as mandated by following section 230 to 232 of the Companies Act, read with Companies Compromise Arrangement and Amalgamation Rules, and to pass an order approving the scheme of arrangement demerger proposed by the resolution applicant in the resolution plan for effective implementation of the plan, and to pass such orders or further orders which may be deemed to be fit and proper in the interest of justice. So Hindustan Photo Films is a public sector enterprise and 100% subsidiary of the Union of India. So it is a subsidiary of the government, and it is possible. Now CD became sick, and BIFER reference was made on 31st March 2003, and order was passed to wound up at that time. So this is a case, a legacy case. A order to of winding up was passed in 2003, but later on, the one of the financial creditors, Canara Bank, filed a Section 7 application to start insolvency proceedings. So some of these public sector enterprises have some assets. There may be land bank, and which is valuable, and there can be some buildings, machinery which are obsolete. So land can be sold, and the land can be purchased by another government, another a department of the government. So in this sense, it is a public enterprise, the CD, and this was possible. So this is the structure: lease land, own land, and own land merged with Messrs. SGS Land Holdings, merged with Messrs. Kimram Exports, and this has been taken under resolution plan by the resolution applicant. And then this is the liquidation value. So total liquidation, and so this is how they have approved. So first there were debates whether against a government company can the insolvency process be initiated. Yes, insolvency application, as we can see here, Section 7 application was filed. However, the assets which were own land, which were valuable assets, they were uh, treated differently in a resolution plan, and for others, plant machinery and all, which were obsolete and there was no buyers, they were liquidated. They were sold in auction as on various basis.
Please explain how during the period of resolution liquidation can be done, and how that liquidation that provisions that is dealt with during the period of resolution. Because the job liquidator's role, responsibility are completely different from that of resolution professional. So how it is dealt with? Because liquidator is a quasi judicial body. Resolution professional does not have that power.
So exactly. So
sir, even if it is sold away, that's a part of resolution plan only. That cannot be said it is liquidated.
So I understand, I hear you, and I hear that this is one of a kind situation, but we have to understand that such a law is not in place as yet. So your observations are well founded, but let us understand that there is no such law in place as yet. However, because this CD is a government undertaking, and January 2023 discussion paper talks about this asset-wise resolution. So hence this order has been approved. So this is what you can consider as for times to come, assuming that there are amendments in IBC are moved in this session and they are approved, then this can be considered in other circumstances as well. So for as of now, let us consider that the resolution plan that is achieved is is in the first stage. So let us assume that, or the situation is that the resolution plan has been received for a particular set of assets which are saleable, and the remaining are not sold. So the COC has approved a resolution plan, and for the remaining they have moved and they moved an resolution that the remaining may be liquidated. So now the question is that IBC wants efficiency. So process certainly must be followed, but efficiency is also required. Although you are right, the IBC prescribes that there should be first resolution, and upon the completion of resolution, the
The
liquidation will
resolution
start.
plan is given by the resolution applicant only. COC cannot give any resolution plan. COC job is to approve or disapprove. COC cannot give any resolution plan.
No. Resolution. See, the IBC has provided a amendment, which is in the sense that the uh, resolution applicant can provide any scheme of arrangement, resolution plan or
Yes,
liquidation
exactly.
or scheme of arrangement. So this is a scheme of arrangement, and the CD has
The
submitted
scheme
a
of
scheme of
arrangement
arrangement.
is that is done during the period of liquidation. During the period of resolution, during the period of liquidation, it is understandable. But during the period of resolution, it is only resolution plan that is given by the resolution applicant. COC
Doctor
does not
Saab,
have any.
Dr. Saab, can I come in with your permission?
Yes, certainly. However, my understanding is that there is no bar from for submitting a scheme of arrangement in the resolution plan. So resolution plan can be in any form, can be in the form of a scheme of arrangement, and certainly the CD itself can also submit a scheme of arrangement during the liquidation. So it is not barred. So this is there are a lot of possibilities, and there is no bar that a resolution plan cannot be in the form of a scheme of arrangement. Yes, Mr. Sharma, please.
Okay. To begin with, the discussion paper of MCA, which talks of bringing a resolution plan for one set of assets and liquidation for other set of assets is totally misplaced. The regulations as framed originally in 2016, if you look at Regulation 37, already provide for this thing that some of the assets of the CD can be sold to RA and other assets can be sold to any party concerned. Again, Regulation 37 clearly provides the restructuring, demerger, merger, and amalgamations are possible during a resolution. So there is a total problem in this case. They have used wrong words. They in fact should have not used the word liquidation. It's in fact a sale of assets, which is allowed under Regulation 37. And I would request my all learned IPs to go back and have a look at 37. Whatever is being discussed in this case law and whatever is there in the MCA is already there in the Regulation 37 since 2016. So you can have a check on it.
Thank you, Mr. Sharma, for that intervention.
Thank you for time, sir.
Okay, so let me continue. Uh, Now, this is the case. I hope you are able to. I hope the PPT is available.
Yes, that is visible.
Right. So some of these cases are with respect to the dues of workmen and employees. Now, what is the role of and how are these dues of workmen and employees considered? So, what is the law? The law that stands is workmen shall have the same meaning as in the Industrial Disputes Act. And Section 5, subsection 20 provides operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Then Section 5, subsection 21, operational debt means a claim in respect of the provision of goods or services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, any state government, or any local authority. Now, moratorium, there is no general rule prohibiting ipso facto clauses. The supply of essential goods or services to the CD may, as specified, shall not be terminated or suspended during the moratorium. Now, section 50, under section 53, in the event of liquidation, the dues owed to the various stakeholders are paid off according to the priority. And this is the list of priority. First are the cost, then are the workmen dues for a period of 24 months preceding the LCD, and debts owed to secured creditors, provided the secured creditor has relinquished security interest. Then you have wages and unpaid dues to employees for 12 months preceding the LCD. Then financial debts to unsecured creditors and government dues, and also the secured creditor which are unpaid following their security interest and realization. Then sixth is any remaining debts and dues, and then comes the shareholders. At seventh are the preference shareholders, and then are the last are the owners. If whatever is remaining are distributed amongst the owners. So this is usually the format which is continuing since 1956. The Companies Act of 1956 in section 529A also provided a similar, not entirely, but something similar. So section 30, submission of resolution plan. So resolution plan has certain mandatory aspects. So what are the mandatory aspects? That must provide for payment of insolvency resolution costs, and then payment of debts of operational creditors as may be specified, which shall may not be less than amount paid to creditor in the event of liquidation uh, or is if in the priority as per section 53. And then whichever is higher and provides for the payment of debts of financial creditors who do not, so the dissenting FC also, and shall not be less than the liquidation. So this is basically, so what we are trying to find out is how the dues of Provident Fund or EPFO are addressed in the IBC. So at both these stages, the resolution plan and in the time of liquidation. So how these are covered under the resolution plan and how they can be addressed during the liquidation. So section 30 provides the mandatory clauses that these are mandatory to be followed in the resolution plan. So in this, the all of the operational creditors, they have to be paid. And now the question is, now let us look into the liquidation, right? So issue is how their claims can be addressed in liquidation. Now, liquidation estate is defined in section 36. And for the purpose of liquidation, liquidators shall form an estate of assets mentioned in section 3. And subject to subsection 4, liquidation estate shall comprise all liquidation assets, which shall include the following, so and so on. So this is now section 36(4) provides that following shall not be included in the liquidation estate assets and shall not be used for recovery. So A, assets used by a third party which are in possession of the CD, including assets held in trust for third party, second, bailment contract, 3, all sums due to any workman or employee from the provident fund, the pension fund and the gratuity fund, and then so on, 6, 4 and 5, contractual arrangements, and then other assets. So what we are addressing here is the issues of pension fund and the gratuity and the provident. So how these are to be addressed. So section 36 subsection 4 provides that these are not to be included in the liquidation estate. So these cannot be included in the liquidation estate, which is used to pay off the creditors as per the waterfall under 53. Now, this is now the rule with respect to operational creditors and the government authorities. In Swiss Ribbons, the Supreme Court of India upheld the constitutional validity of IBC. Court held that the differential treatment of financial and operational creditors does not violate Article 14 due to the existence of intelligible differentia in a separate classification of creditors. However, in this case of State Tax Officer versus Rainbow Papers, the Supreme Court held that as Section 48 of the Gujarat Value Added Tax created a first charge on the property of a dealer to the extent of any statutory dues under such legislation, the state tax authority has a security interest against the city to the extent of such dues, thereby making it a secured creditor. The Supreme Court has earlier held that income tax dues cannot take precedence over dues that are owed to secured creditors. The court further held that the common law doctrine of priority of crown debt would not extend to providing financial preference to the crown debts over secured private debts. In Sundaresh Bhatt versus CBIDIT, the Supreme Court has held creation of a charge in favor of customs authorities under the Customs Act would not elevate their position under Section 53. Now, the PF and gratuity to be kept outside the liquidation estate, salaries of employees working during CRP will constitute the CIRP cost. So in this case of Sunil Kumar Jain versus Sundaresh Bhatt, delivered by the Honorable Supreme Court on 19th April 2022, on a fair reading of Section 5, subsection 13 of the IP Code, dues towards these wages salaries of only those workmen employee who actually worked during the CIRP are to be included in the CIRP cost. The rest of the claims toward the wages salaries of the workmen employees shall be governed by Section 53. So all those employees which are working, their wages and salary will be payable in full as the cost. insolvency resolution process cost. Rest in case of liquidation will be treated as per the waterfall mechanism under section 53. So it has to be established and proved that during CARP, the CD was a going concern and the concerned workmen employees actually worked during the CARP when the CD was a going concern. And then such salaries and wages will be included in the CARP cost. And it was also observed that there is no presumption that the CD is a going concern during CARP period. It has to be decided depending upon the facts of each case. And so far as the dues of workmen employees on account of provident fund, gratuity, and pension are concerned, they shall be governed by section 36(4) of the IB code. And the meaning of this is that section 36 subsection 4 provides for exclusion of third party assets, and the purpose of providing a provident fund is that usually the employer is expected to prepare a fund and park it in some other third party bank or some other place, which is, it's ideally it should not be in its control, but usually this amount is still with the CD and CD continues to use it. So the exclusion under section 36 subsection 4 also extends to provident fund, pension fund, and gratuity fund due to the workers payable by the CD and treat them as third party asset in possession of the CD. And these funds shall be kept out of the liquidation estate, and liquidator shall not have any claim over such funds. So the difficulty is usually such funds are not readily available with the CD to pay the respective workmen. After deduction of these funds, CD is required to remit these funds to the respective regulatory authority. However, when in distress, CD often diverts these funds and usually not in possession of these funds when the RP or IRP takes over the CD. So in such even though these funds are still with the CD or the CD may have used them, but they are deemed to be in control, but they will be deemed to be in possession of the CD. So liquidator is also required to pay these funds out of the sale proceeds of the liquidation estate in priority over the other claimants. So it will be deemed that these funds were created and they are already with a third party. And if they are not in third party, so whenever the liquidator commits such sale, so all of these funds will be paid in super priority over everything else. So they have to be paid in full. And the same was also decided in the case of Jet Aircraft Maintenance Engineers Welfare Association. And NCLAT held that non-payment of complete provident fund amount to workmen and employees in the gratuity payment until the insolvency commencement date amounts to non-compliance with provisions of the IBC. And in this case, NCLAT directed the SRA to make pending payments of provident fund and gratuity dues owed to the workmen and employees until the ICD. So now the scenario is that the workmen dues, provident fund, gratuity, they have to be paid. So provident fund dues, they have to be paid in full till the ICD, and in case of liquidation also, they will be paid in full. So this is as per the observation. CIRP cost, twin conditions to be satisfied: CD must be as a going concern and the employees must have actually worked during the CIRP. Right. So this is now settled law, and now recently in the Jet Airways case, again it has been confirmed that these amount dues have to be paid in full, and the SRA has taken some time, but they will have to pay all of this in full, which is over and above the resolution amount that they have submitted for the resolution plan. So, any questions on this? Yeah, sorry, just opening the PPT. Just a minute. Just let me know if the PPT is available to you. So I will just take two, three more cases and just let me know if you have further questions. So there is a Right. So now in this case of Kotak Mahindra Bank versus Balakrishnan, the Honorable Supreme Court has held that a claim arising out of a recovery certificate is a financial debt. So clause 8 of section 5 of the IBC and so the liability in respect of a claim arising of a recovery certificate would be a financial debt under clause 8 of section 5 of the IBC. As a naturally corollary, the holder of such recovery certificate would be a financial creditor, would be a financial creditor under clause 7 of section 5. So whoever is the holder of a recovery certificate will be a financial creditor and is entitled to file a section 7 application. And nothing in IBC prohibits a decree holder from initiating the CARP against a company. So this decree has now been is now being considered as a secured. Actually, it is a secured. It is a quote, and it is considered to be a financial debt. So, basis the decree, Section 7 applications can be initiated. So, anyone who has faced any such issues, any one of the IPs who may have faced any cases where, on the basis of a decree, the Section 7 applications are being filed. Now, the lease is always an operational debt. So, lease of land by the Noida Authority to builders is operational debt. So, the case of Noida versus Anand Sonbhadra, and in this case, the Noida is the leaser, and whether the Noida they have leased the lands, whether they will be a financial creditor and entitled to be treated so in the CARP, and the Noida in this case had lodged its claim with the resolution professional of the CD therein as a financial creditor. And Noida was a leaser under Section 3 of the UP Industrial Area Development Act. So Noida is providing allotting lands, and this is on a leasehold basis. And whether these leases are for residential land or for industrial land, the Noida is a leaser, and the so-called purchaser or allottee is a lessee. Now, the lease was with respect to a plot leased to the CD in 2010 for a period of 90 years. And the Supreme Court held that according to the Indian accounting standards, the aforesaid lease could not be considered as a financial lease. And the court, while interpreting Section 5, subsection 7 and Section 5, Clause 8 of the IBC, further held that Noida can only be considered to be an operational creditor under the IBC. So I think these are all the questions, all the cases that I wanted to cover with you. And I just now want to open the floor for Q&A. Although I can take up a couple of more cases, but I think we can, take some questions now. So in case you have any questions on any of these cases that I have covered till now. So I'll just take two more cases. So just let me know if the screen share is there.
Yes, sir.
Okay. So, right. So lease by land is, okay. So this is, so we have another very recent interesting case, which is Maitrey Doshi versus Anand Rathi Global Finance. And it is approval of a resolution plan with respect to one borrower cannot discharge the co-borrower. So the Supreme Court has held that simultaneous insolvency proceedings can be initiated against multiple borrowers with respect to one debt. And the Honorable Supreme Court also held that if a certain amount is realized by the FC in the CIRP of one borrower, only the balance amount of the total debt may be realized in the CIRP of the co-borrower in case the debt arises from the same financing documents. And reliance was placed in the decision on Dalit Kumar Jain, wherein it was held that approval of a resolution plan in relation to a CD does not discharge the guarantor of a CD. So now the issues are with respect to the guarantors and borrower and co-borrower. So if so now the bankers, the FCs, have right, and as per the agreement, the liability of all of them are joint and several, but the CIRP or the insolvency application can be filed independently because everybody is responsible. So instead of clubbing together, they can file independent insolvency applications, borrower, co-borrower, guarantor, co-obligors. So separate applications. So it is held that simultaneous insolvency applications can be initiated against multiple borrowers with respect to one debt. Why? Because the rule is fundamental, and the rule is that the responsibility of these borrowers, co-borrowers, is joint and several. This means that in case the share is not decided, so it may be possible that in a loan agreement they may say that for person A, they will be responsible only for 25% of loan or 20% of loan. If it is provided, if the respective shares of the borrowers are provided, then it's a different matter. But usually we are not discussing those circumstances. We are discussing the circumstances that loan is given by a bank or a consortium, and the borrowers, the name of the borrowers are there, who are jointly and severally liable. So this is not like a civil suit where all the names of all the borrowers or all the defendants must be mentioned in the suit. So this is an insolvency or a recovery. In case of insolvency, independent applications can be filed. So because the assets may be maybe in the name of different people. So if there are four people, four borrowers may have four independent assets, and one never knows which is more readily realizable. So accordingly, the rule is very clear, and the commercial logic has been approved, that simultaneous insolvency proceedings, insolvency application can be filed. There is no bar uh, for an insolvency application to be filed, or there is no need, there is no requirement that insolvency application be filed against and named, all of the borrowers should be named in that. So this gives a greater freedom to the FCs to secure their security interest or loans or obligations or outstandings. So even in the jurisprudence in the case of Lalit Kumar Jain is very clear that so the argument were that when the resolution plan is approved, should be treated like a settlement between the borrower and the lender, and when the guarantor is only required to pay the outstanding amount, and in case the amount is settled between the bank and the borrower, then no further obligations should remain upon the guarantor. However, the insolvency resolution is independent and it should not be considered to be a resolution, or it should not be considered to be a settlement. So it is just that the limit of the borrower which is exhausted, and the guarantor has in any case agreed uh, to undertake the burden or obligation of the entire loan amount. So the borrower is not settling with the banker. On behalf of the borrower, the COC is negotiating, and that just absolves the borrower or the corporate debtor from its liability, but the guarantor's liability are not absolved. And against guarantors, independent insolvency applications can be filed. So this is the same jurisprudence which continues. Any questions on this? So question is whether operational creditor holding decree will be considered to be a financial creditor. Well, so if we try to understand who are the people who will get the decree, so the banks, the FCs, will not go to a civil court. So if the banks all the banks are FCs, bank, they already have the right under SARFAESI or the DRT. So if you look at this way, then no FC will be holding a decree. So, okay, so because the FC or the banks or financial institutions are already protected under SARFAESI, or they can resort to the DRT for realizing their loans and obligations. So it is the non-financial institutions. The non-financial institutions include individuals and certainly the operational creditors. So yes, it will always be operational creditors and individuals who will be holding this decree. So thank you for this question. Okay, anything else on this case? Next one is IBC prevails over the Customs Act. So Honorable Supreme Court in Sundaresh Bhatt, liquidator of ABG Shipyard, held that IBC, being the more recent statute, would override the Customs Act 1962. The Supreme Court held that once moratorium is imposed in terms of Section 14 or 33, the Customs Authority only has limited jurisdiction to assess or to determine the quantum of customs duty and other levies. It does not have the power to initiate recovery of dues by means of sale or confiscating of the asset or assets of the CD. The Honorable Court also observed that the custom authorities would have the first charge on the assets of the SSE, which is the CD in this case, except in respect of cases under the IBC and other statutes like the Companies Act, Section 529A, the SARFAESI Act, and the RDB Act. So this is a case of conflict of laws, and you will face several situations where there is a possibility of application of multiple laws. So at that time, you will have to determine which law will govern the transaction. Now, the rules to resolve these issues of conflict of laws are usually that the specific law will prevail over the general, and in case both the laws are specific, like IBC or the Customs Act, then the more recent law will be applicable. So the rule, and even despite the IBC having an overriding effect, but in this case, the Customs Act also has an moratorium, or has a uh, attachment. So in this case, once the moratorium is imposed in terms of the section 14 or 33 of the IBC, the custom authority has only limited jurisdiction to assess or determine the quantum of customs duty and other levies. So this is similar to the other authorities like the EPFO, which we have discussed in the previous slide, that then after the initiation of the CIRP and the moratorium in place, they cannot attach the property. So in this sense, the IBC will override these other laws like the EPFO and the customs also in some of these aspects, like attachment of property and realization. So because again, the rule is that if any authority attaches, they will realize, and ultimately the role and purpose of IBC is for resolution, that is the asset will be sold or will be realized through a liquidator. So the conflict of law is resolved only with the end of the purpose. So in case the Custom Act also will involve attaching and then realizing the property, that purpose should be left to the IBC appointed scheme only. That will also resolve the conflicts. So this is the standard rule which is being adopted. Right, so I will wait for any probable questions or issues. I'm actually coming to my end of the presentation. So I'll just come to the last case that I have to present today. Do let me know if the PPT is available.
Yes, sir.
Yeah, so this is the last case that I intend to present today. This is so the rule is very welcome, and it is settled now. that according to Section 12A of the IBC, an application for initiating the CIRP with respect to CD that is admitted by the NCLT can be withdrawn on an application made by the applicant, therein after obtaining the approval of 90% voting share of the COC. The IBC envisages withdrawal of the resolution application only upon requisite approval of the COC and is silent on withdrawal of that application before the constitution of the COC. The Supreme Court held that there is no bar under the IBC framework for withdrawal of a resolution application before the constitution of the COC. In this case, the Honorable Supreme Court allowed the withdrawal of the resolution application filed by the financial creditor who had subsequently entered into a settlement with the CD in respect of its financial debt before the constitution of the COC. Generally, lenders prefer settlement with the CD given that it ensures quicker recovery for them. So the objective is quicker, efficient resolution, and we have seen those days when the insolvency applications were kept pending, and in the NCLT, the Honorable Tribunal asked the CD whether you are willing to pay or not, and in case no response was there, so I mean in some cases there was suggestion that or there were questions if you're willing to pay or settle or whatever, because at that time initially there was no inherent jurisdiction with the NCLT to allow settlement, and then later on the Honorable Supreme Court exercised its jurisdiction under Article 142 to allow the settlements, and subsequently Section 12A was introduced in the IBC where till the resolution plan, till the usually the EOI, EOI is issued, the resolution plan is this process is done. Usually the settlement can take place. So now the question is that whether the insolvency application can be withdrawn before the constitution of the COC, because the section says that it has to be approved by 90% of the COC, and the COC has not yet been constituted. And mind you that the COC has to be constituted within 1 month of the ICD, and if within 1 month the COC, if within before 1 month or before the COC constitution, the CD approaches the IRP or whoever is the applicant FC, they say that all right, we wish to settle, they can do so and withdraw the application. So this has now been approved by the Honorable Supreme Court in this case of Ashok G. Rajani versus Beacon Trusteeship. So thank you, and any possible question and answers, Q&A.
Sir, I have one question.
Yes,
in
sir,
the
please.
Rainbow case, there was a judgment by Supreme Court that sale tax and other authorities' dues will be at the par of the secured creditors. Now, sir, I think it's already overruled by another judgment or something. So, what is the status of sale tax and other authorities? I'm not talking about the EPF or gratuity or pension fund, but the other authorities is due. Are they at par with the secured debtors, or they are coming as usual as written under section 53? This is what I wanted to know, sir.
No, actually the issue is if there is a particular state act, it's not any other authority. It's whether a particular state act has made such a provision.
It means that you say the special act you want to say, but IBC always overrules because of the new code.
Yes, exactly. You are right.
So I'm
IBC,
talking.
no,
I'm,
but
I'm,
IBC,
I'm only. I only wanted to know it because it was a rainbow case judgment that the sale tax and other dues will be at the par of the secured creditors and not as per the section 53. Is this prevailing or section 53, whatever they say, waterfall, that continues? This is what my question is.
no, sir. IBC does not define secured creditor. IBC does not, define in a way that who will not be a secured creditor. IBC defines who is a financial creditor. IBC is not defining a secured creditor actually.
Okay.
So that is the issue. So if secured creditor is used in section 53, like waterfall mechanism,
Yeah.
and if any state legislation, if any legislation is defining an entity as a secured creditor, then that is the issue that is, was the issue of contention in this sales tax officer rainbow papers case.
Okay. Understood. Thank you.
Okay, any other observation or question?
So during the period of liquidation, the promoter wants to settle all the dues of the creditors. Is it possible?
During liquidation?
Yes, sir.
No, after the resolution, boat has sailed, he cannot do anything.
Mhm.
So in
Okay.
liquidation, again, some innovation was suggested that the promoter can offer a scheme of arrangement. So,
Yes.
but again, section 29A is applicable. So,
Yes.
promoter was, promoter can submit a scheme of arrangement, but should not be barred by 29A.
Right.
So settlement is not there, but scheme of arrangement is there.
Okay.
So I think it's been a long, around 2.5 hours that you have patiently listened to me, and I thank you all for your kind, patient hearing, and I hope the session was informative and useful for you.
Yeah, it was really nice lecture.
So kindly share your presentation also.
Yes, I will send it. I will just send it.
Thank you.
So this presentation will be shared to us here or through the IPA?
I am sending to the IPA. I'm sure they will share it with you.
Okay, sir. No problem. No problem. Anyhow, whichever way works for you, it's fine. Anjali, madam.
Yes, you are, sir. We will share the PPT.
So please share it, madam, in the group so that we'll be able to have it.
Yes, you are.
Okay. Thank you.
Thank you so much, sir. The session was very insightful.
Thank you. Thank you all for the patient hearing.
Can we log out, madam?
Sure, sir. Sure.
Thank you.
Thank you so much, sir, for such a nice lecture.